lie to this honorable,
telling
a lie to this honorable,
to me is more powerful. To me is
than even
more powerful
bringing a medical report.
We've had many medical reports generated outside hospitals. We see them in courts almost on daily basis. We see them in courts almost on daily basis.
Mheshimiwa Speaker, you will remember the rush.
You will remember the rush
when I was asking
that was
to
there
be given
when I was asking
up to 5
to be given
p.m.
up to 5
And it was a rush.
p.m. And
Was
it was
I
a rush to fail to come
Was
back
I
to this
to fail to come
back
at
to
5
this
p.m.
house waiting
at
for
5
a medical
p.m.
report when the
waiting for a
doctors
medical
there
report,
are busy.
when the doctors
attending
there are
to
busy
their patient,
attending
the deputy president.
to their patient.
The
Medical
deputy
reports
president.
I can bring.
Medical
If I've told
reports,
lies,
I can bring.
That is something that
If
can
I've
be
told
established.
lies, that is something that can
And
be
my
established.
learned friend,
And
Mheshimiwa
my learned
Honorable
friend,
Orengo talks about giving
Mheshimiwa Honorable
evidence from
Orengo
the
talks
bar.
about giving
When I was
evidence
learning
from the bar.
when I
They are
was
seated
learning,
down. When he's giving
they are
evidence
seated
from the
down
bar, when he's
about
giving
some cases
evidence from the
filed
bar in Malindi,
about some cases
that I'm not
filed
aware of,
in Malindi,
perhaps that I'm not
he
aware
should
of,
have given
perhaps
us
he
a copy
should have
of
given
that.
us a copy
Mheshimiwa
of
Speaker,
that.
Mheshimiwa
Article
Speaker,
145 Sabbatical 6
Article
is clear,
145 Sabbatical
and I
6
do
is
not
clear,
want to take
and I
time
do
of
not
this
want to
August
take
House,
time
Senate
of this
going
August
back
House,
to it, it
Senate.
applies. Going back to
And
it, it
I would
applies.
plead with you
and
and
with
I would
honorable
plead with
senators
you and with honorable
to give us
senators
until Tuesday
to
give
to
us
see
until
whether
Tuesday
the deputy president will be
to see
well
whether
enough.
the deputy
No
president
one-
will be
No one
well enough.
decides.
No one,
When
no one decides
to get sick
when
and when
to
not
get
to
sick.
get sick.
I
and
am
when
sure
not to
many
get sick.
honorable
I
senators
am
here
sure many
will
honorable
have a
senators
story
here
of their shock.
will have a
Because
story
of having
of
spent
their
an evening
shock.
with somebody,
Because
then
of
the
having
following
spent
day,
an evening
they
with
hear that the
somebody,
person
then the following
is gone.
day,
They
yet
hear that the person
is
was
gone.
looking good and
Yet
healthy.
that
Let's be
person
humane.
was looking
Let's
good
be
and healthy.
compassionate. Let's be
Tuwe
humane.
na utu,
Let's be
kidogo.
compassionate.
Tuwe
Tuesday,
na utu,
the
kidogo.
heavens are not falling
Tuesday,
down.
the
to join
heavens
with the earth.
are not
I
falling
thank you,
down
Mheshimiwa Speaker. To join with the earth. I
Senior
thank
Counsel,
you, Mheshimiwa Speaker.
Paul Mwite.
Senior
There is
Counsel,
Paul Mwite.
a hypothetical
There is a question that was raised by assuming,
Senior Counsel,
and just
Orengo.
an assumption, assuming
Assuming
just an assumption,
the Senate is inclined,
assuming the
inclined
Senate is inclined to grant your
inclined
client up to Tuesday,
to grant your
and by
client
Tuesday,
up to Tuesday,
your client is
and by
unable,
Tuesday,
your client is
to
unable
attend Senate.
to attend Senate.
What then will be the way forward? What then will be the way forward?
Mheshimiwa Speaker, Mheshimiwa Speaker, I would submit the best thing. I would submit the
for
best
this
thing, honorable House,
is
honorable Senate,
for this
to
honorable
make
House,
a
honorable
decision
Senate,
on
to make
facts,
a decision
rather than assuming
on
what
facts,
may or may
rather
not
than
happen.
assuming
Point number
what
one.
may
Point number two,
or may not
Mheshimiwa
happen. Point number
Speaker.
one.
Point number two,
Mheshimiwa
is
Speaker,
the importance of honorable
is the
senators
importance of honorable
seeing with their
senators,
own eyes, seeing
how
with their own eyes, a witness,
how with his times
a witness,
cross-examination, with his
There are
times
many times
cross-examination,
when different
there are many
impressions
times
will be given
when different
by
impressions
written document. And yet, when cross-examination takes place, individuals change their minds. One can only make a decision on whether this witness is believable or not believable when they see his demeanor in person. So there's nothing to replace orality through cross-examination. There are many witnesses whose statements will be impressive, and yet when they begin to give evidence orally, that impression changes completely on the mind of the jury. The Deputy President wishes to subject himself to cross-examination, wishes under oath to deal with the evidence given adverse to him by witnesses here, so that honorable senators can have an opportunity of making a decision. Is it the Deputy President we shall believe, or is it those other witnesses? That opportunity can only come through orality and through cross-examination. So what this House elects to do, that decision, this House, Mheshimiwa Speaker, they will make on Tuesday. I am always an optimist. So I am living in the belief that the doctors may be able to put whatever is wrong with the Deputy President back in place so that he can be here on Tuesday, Mr. Speaker. If he's not here, let that decision of what this Honorable Senate will then do be made on Tuesday. That is a humane way of going about a matter about no one had control of. I thank you.
Now, honorable senators, having listened to the counsel for the Deputy President, as well as the counsel for the National Assembly, I need to consider those arguments and give my considered ruling in this matter. I will therefore suspend for 5 minutes. 5 minutes. 5 minutes, and I'll be back. Arise.
You are watching live pictures from the floor of the Senate, where the House has briefly adjourned. The Speaker of the Senate is expected to come back and give a ruling on the way forward. The council representing the Deputy President has requested that the team be given until Tuesday so that the Deputy President can be given the opportunity to be heard before the Senate takes a decision on the impeachment motion that was forwarded to the Senate by the National Assembly. The National Assembly, through its council, has submitted to the Senate that the evidence that was adduced by the Deputy President in writing be considered in this matter. The National Assembly also, through its legal counsel, has also told the Senate that it is willing to forego the cross-examination of the Deputy President, who was to appear as the sole witness in this historic trial in the Senate. The National Assembly did forward to this House 11 grounds of impeachment, which it believes that it has presented enough evidence to warrant the impeachment of the Deputy President. Among the grounds that the National Assembly did advance is the gross violation of Article 10, Sub-Article 2A of the Constitution, and B and C, Article 27, Sub-Article 4, Article 73, Sub-Article 1A, and Article 2B of the Constitution. The National Assembly, in its submission during this trial, did say that the matter of constitutional compliance, the Deputy President of the Republic of Kenya, who is the principal assistant to the President of the Republic of Kenya, is required to promote constitutional core values such as peace and unity of all Kenyans in the context of ethnic, cultural, and religious diversity, patriotism, national unity, rule of law, democracy, and participation of the people, equity, social justice, inclusiveness, equality, human rights, non-discrimination, and protection of the marginalized, and good governance. It will also respect and uphold representation of Kenya's multi-ethnic and culturally diverse society through the promotion of equality and affording equal opportunities to all Kenyans in appointments to the public service and allocation of public resources, and to promote and implement public policy decisions that do not discriminate against any Kenyan based on conscience, ethnic or social origin, language, or birth. In its argument, the National Assembly said that on diverse dates throughout the last 2 years, His Excellency the Deputy President has persistently made utterances threatening to discriminate, exclude, and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources. Besides, the utterances are highly inflammatory and insightful and significantly undermine national unity and the peaceful coexistence of Kenya's diverse communities. In forwarding its evidence to the Senate for the purpose of this trial, the National Assembly did illustrate instances where it believes the deputy president has been on record committing the said violations. Ground 2, gross violation of Article 147, Sub-Article 1, and Article 152, Sub-Article 1 of the Constitution. The National Assembly states that Article 147, Sub-Article 1 of the Constitution provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. In addition, Article 152, Sub-Article 1 of the Constitution states that the Deputy President is a member of the Cabinet. The National Assembly argues that on various dates throughout the last 2 years, His Excellency, the Deputy President, undermined the President and the Cabinet and the effective discharge of the national government's executive mandate by making unilateral public statements that were inconsistent with policy positions collectively adopted by the government. Under this charge, the National Assembly has moved to illustrate instances and occasions in which it deems the Deputy President to have committed this offense. That on or around 30th of April 2024, the Cabinet passed a resolution for the evacuation of people residing along the Nairobi River. Shortly after that, His Excellency the Deputy President made a public statement opposing the Nairobi River riparian evacuation orders, which the National Assembly argues that the Cabinet had sanctioned for public safety and climate change mitigation. His Excellency the Deputy President made contradictory public statements despite being a member of the Cabinet and being assigned the function of superintending the Nairobi River riparian evacuation order. In addition, the National Assembly argues that His Excellency the Deputy President has on several occasions throughout the last 2 years made public statements contradicting the President on critical matters of governance and the exercise of the President's functions as a symbol of national unity. It has also tried to illustrate that in March 2023, at a public forum in the Nyanza region, the President said Kenya belongs to all, notwithstanding how people voted in 2022 general elections, and that he would ensure the government does not discriminate against anyone. However, His Excellency the Deputy President, speaking after the President at another public forum, contradicted him by saying that Kenya is a company in which the provision of government services is based on shares. That His Excellency the Deputy President has made numerous other utterances at public forums where he publicly restates the division narrative that Kenya is a company in which the rights of citizens are based on shares determined by how various ethnic communities voted in the 2022 general election. The National Assembly argues that the Deputy President's unilateral, divisive, and insightful public statements are impeachable offenses to the extent that they undermine the effective discharge of the national government's executive mandate, that they violate the doctrine of collective responsibility, and that they are equivalent to insubordination of the President, which is incompatible with his constitutional status as the principal assistant to the President of the Republic of Kenya. Ground 3, gross violation of Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, Article 189, Sub-Article 1, and the 4th Schedule to the Constitution. This, quote-unquote, undermining devolution. The National Assembly, in its submission in this trial, argues that Article 10, Subarticle 2A of the Constitution provides that devolution is a fundamental national value and principle of governance. In addition, Article 6, Subarticle 2 of the Constitution provides that government at the county and national levels are distinct and interdependent and shall conduct their mutual relations based on consultation and cooperation. These provisions, the National Assembly argues, that are supplemented by Article 189, Sub-Article 1 of the Constitution, which provides that governments at each level shall perform and exercise their powers in a matter that respects the functional and institutional integrity of government at the other level. Under paragraph 7A of part 2 of the 4th schedule to the Constitution, county governments are responsible for trade development and markets as an exclusive function. Moreover, the Deputy President chairs the Intergovernmental Budget and Economic Council, which the National Assembly argues is an essential organ for consultation between the two levels of government. In its submission before the Senate, the National Assembly, through its legal representatives, say that on or around 20th September 2024, His Excellency Rigathi Gachagua, recklessly unmindful of the high calling and dignified status of the office of the Deputy President of the Republic, unlawfully interfered with the running of Nairobi City County Government by holding a public rally in which he incited citizens against lawful directives of the Nairobi City County Government on the planning and the location of markets. Further, the National Assembly argues that His Excellency, the Deputy President, publicly disparaged the leadership of the Nairobi City County Government and its decisions. Moreover, the Deputy President has interfered with the proper discharge of county government's constitutional functions regarding alcohol and control and regulations. His Excellency, the Deputy President's insightful and demeaning public statements and conduct are impeachable offenses to the extent that they undermine devolution. This is according to the submission by the National Assembly, and that they undercut the functional and institutional integrity of county governments. They unjustifiably vilify and ridicule the leadership of county governments, especially the Nairobi City County Government. Consequently, His Excellency Rigathi Gachagua, according to the National Assembly, has grossly violated Article 6, Subarticle 2, Article 10, Subarticle 2A, Article 174, Article 186, Subarticle 1, and Article 189, Subarticle 1 of the Constitution, as read with the 4th schedule to the Constitution. Ground 4, the National Assembly accuses the Deputy President of gross violation of Article 160, Sub-Article 1 of the Constitution, which talks about the undermining of institutional and decisional independence of judges. In its submission, the National Assembly argues that Article 160, Sub-Article 1 of the Constitution provides that the judiciary shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. Many international law instruments, treaties, and principles require the guarantee of the judiciary's independence and require all government officers and institutions to respect and observe it. In 2023, His Excellency Rigathi Gachagua, according to the National Assembly, recklessly and mindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, and the need to respect, protect, and uphold the independence of the judiciary, made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition for the removal of the said judge in gross violation of Article 160, Subarticle 5 of the Constitution. The Honorable Judge, according to the National Assembly, had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of a judicial function, ordered His Excellency the Deputy President to forfeit to the state the sum of 200 million shillings, which she had found to be proceeds of corruption and money laundering. His Excellency Rigathi Gachagua's public attacks, according to the National Assembly, are impeachable offences to the extent that they undermine the functional and decisional independence of judges. If you're just joining us, these are live pictures from the Senate chambers where the trial has taken a short break. The Speaker has gone to draw a ruling on the way forward for this trial, where the Deputy President has been unable to appear to take to the witness stand. His legal representative, led by Senior Counsel Paul Mwite, has asked the Senate to give the Deputy President until Tuesday next week and thereafter make a decision on the way forward. The National Assembly, through its legal representatives, led by Senior Counsel James Orengo, urged the Senate to consider the evidence that has already been forwarded by the Deputy President. Quoting the law, the National Assembly, through its legal representatives, argued that having forwarded the evidence in writing, there may be no need to have the Deputy President give his account. The team argued that this Senate can make a decision on that, and it is willing to forego the cross-examination of the witness, who is the Deputy President of the Republic of Kenya. So we are waiting for the Speaker to make a ruling on this request by the council representing the Deputy President. Ground 5 of the that the National Assembly believes is an impeachable offense is the gross violation of Article 3, Subarticle 1, and Article 148, Subarticle 5A of the Constitution, which talks about the breach of the oath of office and allegiance. The National Assembly, in impeaching the Deputy President, argued that His Excellency Rigathi Gachagua's actions and utterances outlined in Ground 1, 2, 3, and 4 constitute a gross violation of Article 3, Subarticle 1 of the Constitution, which requires every person to respect, uphold, and defend the Constitution. Further, the actions and utterances of His Excellency Rigathi Gachagua grossly violate Article 148, Subarticle 5A of the Constitution, which prescribes the oath of allegiance of the office of the Deputy President that obligates the Deputy President to obey, preserve, protect, and defend the Constitution. There's also serious reasons, according to the National Assembly, to believe that the Deputy President has committed a crime under national law pursuant to Article 150, Subarticle 1B, Part 2 of the Constitution. Under Ground 6, the National Assembly, in its submission, argues that there are serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Sections 13, Subsection 1A, and Section 62 of the National Cohesion and Integration Act. Section 13 of the National Cohesion and Integration Act provides that it is an offense for any person to use threatening, abusive, or insulting words or behavior where the person intends to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. The section also makes it an offense to use such words or engage in such behavior when having regard to all the circumstances ethnic hatred is likely to be stirred up. The National Assembly argues that besides, Section 62 of the National Cohesion and Integration Act states that a person commits an offense when the person makes statements that are intended or are likely to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. His Excellency Rigathi Gachagua's persistent, inflammatory, reckless, insightful public utterances over the last 2 years, according to the National Assembly, details of which are set out in grounds 1, 2, 3, and 4, establish serious reasons to believe that he has committed crimes under Section 13, subsection 1, and Section 62 of the National Cohesion and Integration Act. Ground 7. Serious reasons to believe that His Excellency Rigathi Gachagua has committed crime under Sections 45, subsection 1, Section 46, Section 47A, Part 3, and Section 48, subsection 1 of the Anti-Corruption and Economic Crimes Act, and Section 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. But for the past 2 years, His Excellency the Deputy President has inexplicably amassed a humongous property portfolio estimated at 5.2 billion shillings, primarily from proceeds of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired, according to the National Assembly, over the last 2 years is incompatible with his non-legitimate income, that is 12 million shillings per annum or thereabouts. That His Excellency Rigathi Gachagua has acquired the above-mentioned property and wealth using his 2 sons, Kevin Rigathi Gachagua, or Kevin Gachagua, and Keith Ikenu Rigathi, and other close family members and associates as proxies. The National Assembly argues that His Excellency Rigathi Gachagua and his proxies, especially the 2 sons, have used a number of companies to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. Anytime from now, we will hand you over to the live proceedings of the Senate, where we do expect in a couple of moments the Speaker of the Senate will walk into the chambers to deliver that much awaited ruling on the way forward. The senators are making their way into the chamber, taking their seats, signaling probably the imminent arrival of the Speaker of the Senate. Just a quick recap. The Speaker adjourned the sitting briefly to draft a ruling on the request by the senior counsel Paul Muite, representing the Deputy President in this historic trial. The senior counsel told the Senate that the Deputy President had fallen ill and he had been in contact with his doctors at the Karen Hospital, and he also did indicate that he didn't speak directly to, and in response, the National Assembly, through its legal team, argued that they do not need to cross-examine the Deputy President, who was scheduled to take to the witness stand, but the Senate should consider using the evidence presented by the Deputy President in his submission to make a decision. The National Assembly, through its legal representatives, argued that the matter before the Senate has strict timelines, and that is waiting for the Speaker to make. Ground 8 is serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. That His Excellency Rigathi Gachagua has continuously misled members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132, Section 29 of the Leadership and Integrity Act. The National Assembly has illustrated in its submission to this trial that sometime in January 2024, His Excellency Rigathi Gachagua made a sensational but false accusation that Honorable Justice Esther Maina, Judge of the High Court of Kenya, had engaged in corruption. He publicly, according to the National Assembly, said he would present a petition for the removal of the said judge, which he has not done to date. But this was amended during cross-examination yesterday of the mover of this motion, Honorable Ekamas Mwengi Mutuse, who said that he has been made aware that the Deputy President has indeed presented of the said judge. There on your screen is the clock of the Senate, and now we await for the arrival of the Speaker of the Senate. Currently the bell is being rung, and we now await the arrival of the Speaker. Ground 9. And there is the Speaker of the Senate, who is now walking into the chambers. This broadcast is brought to you by the Parliamentary Broadcasting Unit in conjunction with the Kenya Broadcasting Corporation.
Order, honorable senators. Let me apologize, I've taken more than the 5 minutes. The matters that had been raised are weighty, but I'm ready with my ruling and I proceed to deliver it. Honorable senators, ladies and gentlemen, as you will recall, before the rise of the Senate at 1:15 p.m., the Senate had concluded the hearing of the case of the National Assembly. This including the calling of its witnesses who were examined, cross-examined by counsel for the Deputy President, and re-examined. As the House adjourned, I directed that, as contained in the hearing program in this matter, of the determination of the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on resumption at 2:30 p.m., the Senate will hear the case of the Deputy President for 2 hours, comprising examination in chief and re-examination, while the National Assembly will have a period of 5 minutes for cross-examination. When the Senate resumed at 2:30 p.m., when the opportunity came for the Deputy President's side to commence its case, Senior Counsel Paul Mwite, counsel for the Deputy President, informed the Senate that he did not know the whereabouts of his client and sought to be allowed a little time to establish where he was. Thereafter, he informed the Senate that he had landed ill. Asked how he proposed that the Senate proceeds, counsel for the Deputy President requested for time, possibly up to 5 p.m., to try to meet his client before advising on the way forward. Argued that unfortunate as the situation was, this being a constitutionally time-bound, that pursuant to Rule 11, Senate standing orders, the proceedings proceed. Now I'll read Rule 11. It provides thus: all the deputy appear before the Senate